you hear me, please let me know. I am working on turning this music off and getting a sound check. What's up? Let me know if you hear me, please. All right, let me make sure. Okay, you hear? Good job. Thank you for letting me know. See who we got here. All right. Okay, let's say hello to Icy Cat. And thanks for becoming a member, Icy Cat. Member for 1 month. Thank you so much. Hope you're on the mend and feeling better. Mostly, mostly, and welcome. And Michelle, welcome. Michelle is here, and Bonnie's here. What up, Bonnie? Hello, Prof and Chad. Uh, Tracy Fleetwood. What's up, Tracy? Tracy's here. What's up, guys? Well, lurkers, join the chat. Come on. Um, we got 3 girls in the chat. Take advantage of the chat to have a good time. And welcome in, Kayla. Hello. Um, Welcome, everyone. So good to see you here. It's June 18th, Tuesday, and we have this new document that has dropped. And so I want to go through that quickly with you and have some things to do this evening. So I'll get off. I won't be on all night. But what's up? Before we get started, I need to take another drink of water. I'm on antibiotics that are dehydrating the hell out of me. So get some more water. And then read a little something for you before we get started. So, I sit back with this pack of zigzags and this bag of this weed. It gives me the shit needed to be the most meanest MC on this earth. And since birth, I've been cursed with this curse to just curse and just blurt this berserk and bizarre shit that works. And it sells and it helps in itself to relieve all this tension, dispensing these sentences, getting the stress that's been eating me recently off of this chest, and I rest again peacefully. But at least have the decency in you to leave me alone when you freaks see me out in the streets when I'm eating or feeding my daughter. To not come and speak to me. I don't know you, and no, I don't know you a motherfucking thing. I'm not Mr. NSYNC. I'm not what your friends think. I'm not Mr. Friendly. I can be a prick. If you tempt me, my tank is on empty. No patience is in me. And if you offend me, I'm lifting you 10 feet in the air. I don't care who was there and who saw me just jaw you. Go call you a lawyer, file a lawsuit. I'll smile in the courtroom and buy you a wardrobe. I'm tired of you all. I don't mean to be mean, but that's all I can be. It's just me. And I am whatever you say I am. If I wasn't, then why would I say I am? In the paper, the news, every day I am. How the radio won't even play my jam. Because I am whatever you say I am. If I wasn't, then why would I say I am? That's just the way I am. Welcome in, Lisa. Welcome in, Captain Underpants. Yes, it was a genius rant by Eminem, The Way I Am. And whatever you say I am. All right, so um, let us not delay too long because this is way too much reading. and I'm going to try to get through it quickly as possible. So we're going to look at this Q's response to this court's May 31st, 2024 order or judgment of the court and notice of conflict. On May 31st, 2024, this court issued its order of judgment of the court concerning the defense's request to have the judge disqualified. Contained in said order were several errors. The defense is filing this motion to preserve those errors for future courts, if needed, and to notify the court that due to new information learned in her order, a conflict has been revealed which has caused Judge Gull to become a witness. The defense files this response and notice for purposes of maintaining a record and does not wish for this pleading to delay future hearings from taking place. Particularly hearings related to the defense's request to transfer Richard Allen out of the DOC, which is the most urgent of the pending matters that need litigated. Also, the defendant's response is intended to provide correct information to Judge Gull as she continues to self-evaluate her obligation to recuse herself in the case should she believe that bias or the appearance of bias exists. A judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is filed. Okay. In this motion, or in his motion to disqualify, Mr. Allen noted that according to a June 14, 2023 report filed by the Carroll County Sheriff's Office, Judge Gull advised the Carroll County Sheriff's Office that it could ignore a valid defense subpoena for Westville Correctional Facility inmate Robert Baston and refuse to transport him to the June 15, 2023 hearing. Mr. Allen's emergency motion to modify safekeeping order. The defense further alleged in its motion to disqualify that because Judge Gull's actions, the defense was without a key witness for the hearing. I may have skipped over a word there, because of Judge Gull's actions. But yeah, they were without a key witness who was Mr. Robert Baston. It was anticipated that at the June 15, 2023 hearing, Mr. Baston would testify as to the harsh, abusive, and unconstitutional treatment of Richard Allen at Westville Correctional Facility. Remember, some of those allegations were in the form of a letter that he had written. The failure of the Carroll County Sheriff's Office to transport the witness from Westville left Mr. Allen without crucial evidence for the hearing, thereby subverting justice for him. However, in her May 31st, 2024 order, Judge Gull claims that she never advised the Carroll County Sheriff's Office to ignore the subpoena and leave Baston behind. Judge Gull's claim contradicts the Carroll County Sheriff's Office report that this court received on June 20th, 2023. The June 14th, 2023 report, which was ordered by the court, stated the following. On June 14, 2023, I Special Deputy Wiskoski Bryan, while on duty, was conducting transport from Westville Correctional Facility to the Carroll County Jail. Upon my arrival, I was escorted to Baston Robert, DOC 209-210, segregation unit to conduct the pickup. After waiting, a corrections officer approached and told me Baston is refusing to come out of his cell and told the corrections officer, "F you can't make me go." Corrections officer told me that they will do a cell extraction to get him to my transport vehicle. I told the corrections officer to stand by and let me make a few phone calls. I was escorted back to the main gate where I was greeted by John Gallipo. You know who that is. I called Carroll County Jail Commander Lori Sistarik, who I explained the situation to. She then made a phone call to the Chief Deputy, Tobe Lesby, who contacted Judge Francis Gull's office to inform them of the situation. Francis Gull's office advised to leave Baston there if he did not want to attend the court hearing that is scheduled for 6/15/2023. I then spoke with Warden and asked if he could provide me with a letter stating that Baston refused to come out of his cell and he did not want to go. Warden Gallipo agreed he would. He advised he would bring me the letter on 6/15/2023 to Carroll County Courthouse so I could attach it to his report. Nothing further at this time. The report was approved by Tobe Lesenby, who is a key witness in this case. Juxtaposed to the Carroll County Sheriff's Office report is Judge Gull's May 31st, 2024 order, in which she stated, the decision by the deputy to leave without the witness was his and not directed by the court. That's pretty interesting. Pretty interesting. The first time that Richard Allen's counsel learned of these contradictory stories was in Judge Gull's May 31st, 2024 order of judgment of the court. Judge Gull has possessed this report since June 30th, 2023. Upon reviewing this report nearly a year ago, Judge Gull never notified Mr. Allen's attorneys of the misrepresentation contained in the report, as it related to her purported involvement in the failure to transport Mr. Bastion to the hearing. At the very moment of learning that Carroll County Sheriff's Office filed a report with fabricated facts concerning Judge Gull, she should have immediately alerted Mr. Allen's attorneys of the misrepresentation contained in the report. Further, upon Judge Gull learning of the misrepresentation contained in the report, which never undermined the evidence Mr. Allen was able to present, which undermined the evidence Mr. Allen was able to present. Judge Gull never reset the hearing so Mr. Allen could present the very evidence Judge Gull said was lacking when she denied Mr. Allen's emergency motion to vacate the safekeeping order. Additionally, as this court is aware, Mr. Allen has filed 4 Frank's motions indicating that law enforcement has acted intentionally or in bad faith. Also, as this court is aware, Mr. Allen has filed 2 separate motions to dismiss based upon law enforcement's destruction of evidence. One of those motions was heard on March 18th, 2024, with the court denying said motion on April 2nd, 2024. To prevail on a motion to dismiss as it relates to the destruction of potentially useful evidence, the motion to dismiss requires the defense to prove that law enforcement acted in bad faith. At the March 18th, 2024 hearing, defense counsel was attempting to provide evidence to the court that law enforcement has acted in bad faith over the course of this case. At that time, the court was aware that law enforcement had fabricated facts contained in the June 14th, 2023 report, thereby acting in bad faith. Yet this court never alerted the defense, and therefore law enforcement's bad faith was not made part of the record. Even if this court would still claim that such a fabrication in a report would not have changed her ruling on the motion to dismiss, the fact is that the defense was not able to include that information on the record for the Court of Appeals, should it be necessary. Additionally, had Judge Gull alerted Mr. Allen's attorneys of the Carroll County Sheriff's fabricated statement in that report, the defense could have used that fabricated statement when pursuing their Frank's motions and motions to dismiss in order to provide additional evidence of intentionality and bad faith on the part of Carroll County Sheriff's Office. Furthermore, by failing to provide this information to Mr. Allen's attorneys, Judge Gull prevented the defense from investigating this fabricated story, including through depositions. Judge Gull should have alerted Mr. Allen's attorneys of the Carroll County Sheriff's Office fabricated facts written in their police report well before March 18, 2024. Before that motion to dismiss, and her failure to do so provides a rational inference of bias. If that is indeed what happened. Okay. Now, there's a claim that Judge Gull is now a witness in this matter as to Tobe Lesenby's credibility. Given that Judge Gull is the only individual who knows that she did not direct the Carroll County Sheriff's Office to ignore the subpoena and leave Mr. Baston at Westville, despite the contrary assertions in the Carroll County Sheriff's Office report, she has become a witness to Tobe Lesenby's truthfulness and to the fact that the information contained in Carroll County Sheriff's Office report is false. If it is. And I would venture to say, is she lying or is Tobe Lesenby? The credibility of a witness is always an issue for the jury. If Judge Gull's story is correct, then she had a ringside seat to the intentional behavior of the Carroll County Sheriff's Office and or the bad faith of the Carroll County Sheriff's Office in that it, one, intentionally ignored a valid defense subpoena for a defense witness, and then two, fabricated a story in a police report claiming that the sitting judge on the case authorized the Carroll County Sheriff's Office to ignore the valid defense subpoena. In this scenario, Judge Gull is a witness. Okay? At future hearings and at trial, the defense should have the ability to cross-examine Tobe Lesenby on these contradictory stories with questions similar to the following. Mr. Lesenby, the defense attempted to bring a witness named Robert Baston to testify at a hearing concerning his observation of guards abusing Richard Allen in a variety of ways at Westville, but your office ignored a valid subpoena to bring that witness to a hearing. Isn't that right? You did not want the judge to hear testimony of that witness because it would support the defense's contention that Richard Allen was being abused by Odinist guards and should be moved to Cass County Jail closer to both his family and attorneys and away from the abuse. You wanted Richard Allen to remain in the Westville prison so that he would continue to be housed far from his attorneys and family, while emotionally vulnerable to the abuse he was suffering at Westville at the hands of Odinist guards. Worse yet, you then lied in a report claiming that Judge Gull advised you that it was okay to leave Baston behind. You lied about that in your report? Judge Gull never told you that it was okay to ignore a valid defense subpoena, did she? I am handing you Exhibit 85, which is the June 14th, 2023 report from Carroll County Sheriff's Office, in which you claim that Gull gave the directive allowing you to ignore the subpoena, etc. Because the defense is claiming that law enforcement has acted in bad faith, and bad faith is an important component in its motions to dismiss as well as the 4 Franks notices, it must be able to call Judge Gull to the stand to testify concerning the false statements contained in the Carroll County Sheriff's Office June 14, 2023 report. Judge Gull's testimony is especially vital concerning the defense motions to modify the safekeeping order, as well as their Franks motions and motions to dismiss. Calling Judge Gull to the stand to testify as to the fabricated facts contained in this report is especially important when the very witness who is the subject of this report, Robert Baston, would have testified about Richard Allen's treatment at Westville, which directly led to the deterioration of his mental state and false statements concerning his involvement in the crime. The defense plans on issuing subpoenas and calling Judge Gull to the stand at future hearings and at trial to testify that she never directed Carroll County Sheriff's Office to ignore a valid subpoena, and also never advised Carroll County Sheriff's Office to leave Robert Baston behind if he did not want to attend the June 15, 2024 hearing. Judge Gull should recuse herself from this matter as she is now a witness in the proceedings. All right, Judge Gull's failure to admonish the Carroll County Sheriff's Office may cause law enforcement to believe they can create fabricated stories in this case with no consequences. That's an interesting point. 33. Despite having the Carroll County Sheriff's Office report since June 20th, 2023, to this day, Judge Gull has failed to admonish the Carroll County Sheriff's Office for filing a report that contains such a flagrant falsehood which is arguably an attempt to cover up their illegal actions in ignoring a valid defense subpoena. Let's read that sentence again because it's a very interesting sentence. It's arguably an attempt to cover up their illegal actions in ignoring a valid defense subpoena. Judge Gull's failure to address that fabrication in any fashion whatsoever provides a basis for the state's witnesses to believe that they can freely fabricate stories which subvert justice for Richard Allen without consequence. This provides a rational inference of bias. Judge Gull continues to errantly accuse the defense of improperly filing ex parte documents. In its May 31st, 2024 order, this court continued to claim that the defense is to blame for ex parte pleadings that were accessible to the prosecution. On March 7, 2024, Attorney Rozzi alerted Judge Gull about his grave concerns surrounding McClelland receiving the ex parte documents. It took Judge Gull 13 days to respond to this urgent matter. In her March 20th, 2024 emailed response, Judge Gull wrote to defense counsel, quote, "I would encourage you to educate your staff on how to properly file pleadings." Yeah, remember, we've seen that. Attached is a printout from the drop or DocsPop filing process of the February 26, 2024 ex parte document that court staff mishandled, causing accessibility of the document to the prosecutor. In her May 31st, 2024 order, Judge Gull seems to believe that parties can only file ex parte documents through the Odyssey platform. If so, she is incorrect. Parties may also file ex parte documents through the DocsPot platform, which is the platform defense staff utilize when they correctly filed the February 26, 2024 ex parte document in this case. Over the course of this case, defense staff has used both Odyssey and DocsPot platforms when filing ex parte documents. It is telling that the tutorial Judge Gull sent to the defense details how court staffs should process ex parte documents they receive in the Odyssey platform, not the DocsPop platform. Now, isn't that interesting? There should be this should not be any ambiguity to this, right? There shouldn't be. So, which is it? So, which is it? I mean, let's talk facts. Is it only the Odyssey platform that can be utilized to file ex parte documents? Or can the DocsPop platform be used to file ex parte documents? That's interesting. Which is it? Judge says one thing, defense says another. Which is it? How does it go in every single other case in that county, in that courtroom? Would the clerk be the one who's the authority on that? Okay, it should be noted that upon receiving this February 26, 2024 pleading, court staff would see in bold font and capital letters at the top of the pleading the following: ex parte pleading to be placed under seal, which should have easily alerted court staff of the ex parte nature of the document, causing them to follow proper procedures in processing an ex parte procedure or pleading. But once again, what's the actual fact about the proper way to do this? The staff for the defense filed the ex parte documents correctly. The docs pop printout shows that the only service contacts listed on this ex parte filing were Brad Rossi and Andrew Baldwin, not Nicholas McClellan, James Luttrell, or Stacy Diener. Furthermore, the printout shows that all documents were marked as confidential. There is nothing else further that the defense can do to prevent these documents from being made public or misdirected to the prosecution after the defense correctly files the ex parte document. The defense must then trust that the court staff has been properly trained on how to navigate an ex parte filing, whether it is filed using Odyssey or DocsPop platforms. In this case, after the defense correctly filed the ex parte motion, allegedly, once again, what is correct? Somehow court staff erred in how it processed the document into the system, causing Prosecutor McClellan to have access to the ex parte document. Unless it was not an accident, but strictly intentional. In her May 31st, 2024 order, Judge Gold detailed how she sent the defense a tutorial paper authored by JTAC explaining the process. The court implied in said order that she sent the tutorial to the defense in order to assist the defense in learning the proper process of how to file an ex parte motion. Judge Gold's presumption that this tutorial assisted the defense is inaccurate for three reasons. One, the defense was not errantly filing ex parte documents. Two, the tutorial Judge Gold sent to the defense had nothing to do with assisting practicing lawyers on how to file ex parte documents. And three, the defense continued to file ex parte documents in the exact same manner it had been filing before Judge Gold ever sent the tutorial to defense, and there were no issues. In her May 31st, 2024 order, Judge Gold, referring to an email in which she provided the JTAC tutorial, stated, quote, "Since that communication, defense have had no issues with their staff properly filing ex parte pleadings," close quotation. This court attempted to give credit to the JTAC tutorial for her claim that no ex parte issues occurred after she sent the tutorial to the defense. However, this is simply not true, as the tutorial provided no guidance for practicing lawyers, and, as discussed above, the defense was already correctly filing ex parte documents. It seems likely that the actual reason for no further ex parte issues was that the court staff actually learned the proper manner in which to process ex parte documents. It's kind of spicy. Is this heating up? Sure does seem like it's heating up. The tutorial Judge Gold emailed to counsel is actually intended to assist court staff and clerks in how to properly handle ex parte documents after the private practitioner has filed the ex parte document. In other words, the document that Judge Gold refers to in her order does not in any way assist the practicing lawyer in filing ex parte documents, as it is a tutorial for court staff. Please find attached a printout of the tutorial Judge Gold sent the defense marked as Exhibit B, which also includes the cheat sheet referenced in the letter from the Office of Court Services. Okay. I want to do something before I go further. I'm not sure how fast I can work this out. See how fast I can send this over. In the meantime, I want to say hello to whoever came in. Noe, Rebecca Ann, Lambert, Tommy. Come on in, and thanks for joining. Now let me see. Okay, got that one. I failed to do this ahead of time. I apologize. I think it's important to look at these before we finish this. Let's see. Hello, Bill. What's up? Thanks for coming in. All right, let's see. Downloading. All right. All right, and we're going to download that. Can't do it any faster. I apologize. Okay. Hey, what's up, Frenchie? Thanks for coming, French. All right, now let me send these over to the software here. See if I can do this quickly. Let's see. I want you to be able to see these exhibits. Okay, we'll start with this one. That one's ready to go. All right, in the meantime, let's go back before I pull this. Let's see. Let's show it. Okay, this is Exhibit A. Attached is a printout from the DocsPop filing process of the February 26, 2024 ex parte document that court staff mishandled, causing accessibility of the document to the prosecutor. Okay, so this is a copy. So let's look. Take a look at it. So see what I see here is it says filing description, verified ex parte motion for hearing on funding for expert services, filing type M, motion filed, filing status accepted, document name motion. Then there are 1, 2, 3, 4, 5, 6, 7 attachments, proposed order, proposed ex parte order on funding for expert services. Oh, so it looks like a receipt. I mean, look at it. It's pretty clearly stated, okay, as ex parte. Now, like I said, which is correct? Okay, which is correct? The claim of Gull or the claim of the defense here in this document? It should not be, I mean, there should not be any ambiguity in it. Shouldn't it be standard protocol and as to how things work? All right, now let's look at this one. This is the one we were just discussing, Exhibit B. So let's take a look at Exhibit B here. Hey, welcome in Frenchie6290, Noe, Rebecca Ann, everyone else who came in. Look at here. Okay, let's see what this says. Remember, so let's go back. Oh, let me go back so we can reference what is being said here. Okay. The tutorial Judge Gull emailed to counsel is actually intended to assist court staff and clerks, right? Please find attached a printout of the tutorial. Okay, so let's take a look at it quickly. It says, to all judicial officers regarding proper processing of ex parte filings in Odyssey. As a reminder, ex parte is Latin term meaning by or for one party. The term refers to an attorney's or unrepresented party's communication with a judge or legal proceedings conducted without notice to and outside of the presence of other parties. Typically, ex parte proceedings are permitted only when a party needs urgent relief that cannot wait until the adverse party is informed of the request and given an opportunity to respond. Ex parte court documents that are filed via e-filing or conventional filing must be handled differently than other filings. Documents that are ex parte should be marked with the document security group access limited to clerk and or to court and clerk. This ensures that other parties or attorneys cannot access the filed documents. Okay. See the cheat sheet on how to process ex parte filings in your e-filing review queue in order to make sure these documents are marked properly before they are added to Odyssey. Choosing the wrong document security group will expose the filing to other parties. Okay. I'll skip ahead some. And you see there are some instructions on what to click. Access limited to clerk and court. Okay. Here's the important part here at the bottom, 3A. To process these filings, the reviewer should edit each filing. Okay. For ex parte motion or any ex parte document, the reviewer selects the M motion filed code, then, unless otherwise instructed by the judge, changes the security group to access limited to court and clerk. Access limited to court and clerk. See that? And it says the reviewer saves, then accepts the envelope. Once accepted, the documents will appear in Odyssey with the access limited to court and clerk security group. Okay, then there's a manual instruction here. Okay. Now, let's continue. All right. There we are. Even though on its face, this tutorial clearly appears to directed to assist court staff in understanding how to process, accept ex parte filings, the defense's staff still reviewed the tutorial sent to Judge Gull to determine whether any part of the tutorial was meant to assist a practicing attorney in how to file an ex parte document. It does not. When defense staff clicked on the link detailed in step 1 and attempted to sign in, they were presented with a prompt that states, "You are not authorized to use this site." This is because, again, the tutorial that Judge Gull proclaimed in her order as helpful to the defense was actually meant for court staff. Okay. There you go. Hey, thank you, Bonnie. Bonnie sent a super chat. Thank you. Thank you very much, Bonnie. That's sweet. Thank you. All right. Thank you very much. It says, let's celebrate their fifth super on a live stream. That's very generous, Bonnie. Judge Gull has failed to admonish Prosecutor McClelland for improperly reading ex parte pleadings while continuing to denigrate defense counsel. Now I gotta admit that right there is rich. That's nice. That's something I would agree to, because clearly he would have seen in very clear fashion at the top of the document ex parte. The pleadings, errantly made accessible to Prosecutor McClelland, were clearly marked ex parte. That's what I just said. That's what I just said. The defense became aware that Prosecutor McClelland read the ex parte documents based upon a March 6, 2024 prosecution filing in which the prosecution directly quoted from the defense's ex parte filing from February 26, 2024. This document was clearly marked in capital letters at the top of the document, ex parte pleading to be placed under seal. I mean, is that not clear enough? I mean, I know the Delphi crazies will not agree. They will not agree. Just think about the ethics of the situation. He opens it or takes a look at it, or if it's on a computer screen, he opens a document, he looks at it. In all caps at the top of the page, it says, ex parte pleading to be placed under seal. Shouldn't he have immediately stopped and closed it and said, "Oh, F, I shouldn't be nosing around in this document"? Just have a little ethic. After reading Prosecutor McClelland's March 6, 2024 filing and realizing that McClelland had reviewed a defense ex parte document, Attorney Rozzi sent an email to Judge Gull and one of Judge Gull's staff members, as well as to Nick McClelland. Find attached copy of said email, marked as Exhibit C. The email respectfully questioned how an ex parte motion was made accessible to the prosecution. Okay, so let's look at it. Let's read that before we go any further. All right, now you will see here from Brad Rozzi. March 7, 2024. To Leslie Ross, Francis Gull, Nick McClelland. Subject ex parte filing. Judge Gull, you may be aware that I filed an ex parte motion for funds on 2/26/24, which contained confidential information regarding our client's defense. We have double checked and confirmed that the only two individuals CC'd on the motion were myself and Andy. This morning, I received an e-notice of a filing by Mr. McClelland requesting Dr. Westcott's records, and in his filing, there exist specific quotes from my ex parte filing on 2/26. Unless I am missing something here, this would suggest that Mr. McClelland has a copy of my motion. Naturally, this is concerning. In an effort to not jump the gun on this, my staff member did reach out to Karen in Carroll County Circuit Court to confirm that she processed the motion in accordance with the ex parte confidential filing procedure, and she assured my staff that she did. I am not looking to point fingers here, but I think it's fair for me to inquire as to why our client's ex parte filing is not being treated as a confidential filing. I also think it's fair to inquire as to why the prosecutor would not only read the filing, knowing that it is noted as an ex parte pleading to be placed under seal, but moreover, why after reading the filing, the protected information would be reduced to a pleading and publicly filed by the state. In a normal situation, I would simply pick up the phone and call Mr. McClelland to get to the bottom of this matter. But he has already made it clear to Andy and I that he will not communicate with us over the phone. I have no interest in engaging in dueling emails over such an important matter, so I am seeking your assistance. I would appreciate your thoughts on this and how to remedy the situation. Of course, I am open to Mr. McClelland's input as well. And finally, I am happy to discuss this by phone. Also, there is the fact that the state's pleading is currently accessible to the public. Can't put the genie back in the bottle, but the remedial measure of removing the filing would be appreciated. I look forward to hearing from you. I mean, that's pretty gentle as could be. That's delicate words there, right? Now, then on March 7th, 2024, Prosecutor McClelland filed a pleading in which he finally admitted that he also had access to 3 other ex parte filings. After reviewing the record, the defense believes that Prosecutor McClelland actually reviewed only 2 ex parte filings, as 2 of the filings that he referenced in this pleading he identified as ex parte are actually not ex parte filings. I mean, does it seem like we're crossing into some dangerous territory when it comes to appeals court? Despite the clear marking of ex parte on the documents, Prosecutor McClelland chose to read those ex parte documents rather than promptly deleting them and alerting the defense of the misdirected filing as required under Indiana Rule of Professional Conduct. I'll quote from it. A lawyer who receives a document relating to the representation of the lawyer's client and knows or reasonably should know that the document was inadvertently sent shall promptly notify the sender. Prosecutor McClelland never contacted defense counsel after reviewing or receiving the ex parte documents as required under IRPC 4.4b. The defense only learned of this violation upon reviewing McClelland's March 6, 2024 pleading, in which McClelland audaciously quoted directly from the ex parte document, thereby making said quote available for public view. The act of McClelland reading from the defense's ex parte documents provided the prosecution with an entirely improper glimpse into the manner in which Mr. Allen's attorneys would be defending him. This is yet another example of a subversion of Richard Allen's due process rights. This court has failed to reprimand the prosecution for reading ex parte documents or even to address that issue in any way whatsoever. Nor has Judge Gull filed a pleading in which she publicly proclaimed that she is referring Nick McClelland to the Office of Judicial and Attorney Regulation Executive Director Adrian Mehring for that office to enforce the rules or determine counsel's ethical misconduct. This court publicly declared in its April 30th, 2024 order that it was referring defense counsel to the Office of Judicial and Attorney Regulation concerning a short and bland press release that defense counsel sent out to media sources when no gag order was in place, and after the prosecution and law enforcement had conducted multiple press conferences and issued multiple press releases over the course of the investigation. Meanwhile, on the much more serious allegation of McClelland reviewing ex parte documents, plural, and violating IRPC 4.4b, Judge Gull has said or done nothing. Judge Gull is clearly treating the prosecution differently. than the defense counsel, and this provides a rational inference of bias. This court offered its hand-picked public defenders an opportunity for a hearing on a Franks motion, but denied the same opportunity for attorneys Baldwin and Rozzi, which is nuts. That's nuts, by the way. Absolutely nuts. I don't see how it's even possible. In her May 31st, 2024 order denying the defense's request for disqualification, the court maintained that it has no bias against defense counsel. On January 22, 2024, this court denied Baldwin and Rozzi's request for a Franks hearing. At that point in time, this court had failed to rule on the Franks request for over 4 months. Yet, within 4 days of the re-entering of their appearances on the case, Judge Gold denied their request without hearing. However, after Baldwin and Rozzi were taken off the case in October 2023, remember this? Judge Gold informed her newly hand-picked public defenders that they should review prior counsel's pleadings and either adopt those pleadings or make their own. In that November 14th, 2023 CCS entry, it was memorialized that Judge Gold informed the new public defenders, Scrimmin and Librado, that, quote, if defendants' new counsel inform the court that they intend to pursue the Franks motion, the court will schedule a hearing, close quotation. Pardon me. Such action demonstrates that this court is punishing Richard Allen due to her bias against attorneys Baldwin and Rozzi, in that after they re-entered their appearances, she quickly denied Allen's original counsel a hearing on the Franks motion while offering replacement public defenders an opportunity to have a Franks hearing soon after their appearance on the case. Yes, how is that proper? I'm just, sitting back as an observer, I wonder, how is that proper? It's not about the attorneys, it's about the defendant. So how is it proper to not extend to the defendant a single remedy, like a hearing, but instead make it contingent upon whether or not it's these attorneys or these attorneys representing that defendant? It makes no sense to me, because it's not about the attorneys, it's about the defendant. It's his hearing. This disparate treatment of attorneys Baldwin and Rozzi compared to this court's treatment of the prosecution and even of the replacement public defenders provides a rational inference of bias against defense counsel Baldwin and Rozzi, and therefore against Richard Allen. In its order, this court claimed that it is irrational and unreasonable for the defense to assert. The court is also averring that defense counsel are lying about their experiences in other courts around the state of Indiana. Furthermore, the court maligns defense counsel concerning its knowledge of the jury rules, when it is the court that is incorrect in its assessment of the jury rules. Ooh, that's pretty bold. At the May 7, 2024 pretrial hearing, the court stated, well, you understand. Well, maybe you don't understand. Jury Rule 4 requires that I issue summons to the jury with the dates of the trial. Jury Rule 4 requires that I issue summons to jurors with dates. Okay. 61. The court cited Jury Rule 4 as a basis for limiting the trial or the time of the trial. However, Jury Rule 4 does not ever discuss the length or dates of the trial or require courts to place a hard end date for a trial. Jury Rule 4 states that, quote, not later than 7 days after the date of the drawing of names from the jury pool, the jury administrator shall mail each person whose name is drawn a juror qualification form and notice of the period during which any service may be performed. Jury Rule 4 is primarily referring to the time span or term during which citizens need to be on the alert that they could be summoned in for jury duty. That is, when they are on call for possible jury duty. The prospective juror needs to be aware that over the course of a specified number of months, the court may summons them to appear in court as a potential juror at a later date. Jury Rule 4 further states that when summoning a prospective juror in for jury duty that, quote, the summons shall include the following information: directions to the court, parking, public transportation, compensation, court policies regarding the use of electronic communication devices, that is, cell phones, PDAs, smartphones, etc., attire, meals, and how to obtain auxiliary aids and services required by the American with Disabilities Act. Note that Jury Rule 4 does not require the court to provide the dates of the actual trial or the length of the actual trial, nor does Jury Rule 4 require the prospective juror to be advised of the beginning date or end date of a trial. Jury Rule 9, term of jury service, states, quote, a person who appears for service as a petit juror serves until the conclusion of the first trial in which the juror is sworn, regardless of the length of trial or the manner in which the trial is disposed. Once summoned in and selected as a juror, Jury Rule 9 is the jury rule that comes closest to referring to the length of the actual trial. Note that Jury Rule 9 places no limit on the length of the actual trial once a juror is selected, nor does Jury Rule 9 place a hard end on the conclusion of any trial. Indeed, by stating that the juror serves until the end of the first trial, regardless of the length of the trial, the authors of the jury rules innately understand that courts will not have the foresight to include an actual end date to a trial. As proof, in larger counties, jurors are summoned for a particular day and could be chosen to serve on any number of trials of varying lengths. In Marion County, for example, prospective jurors arrive and gather in a large room, not knowing which court or what trial they may be called upon to serve. As often, multiple jury trials are conducted at the same time and on the same day. The prospective juror could be asked to serve on any one of those trials. In spite of Judge Gull's proclamation that at the May 7th, 2024 hearing, Indiana jury rules do not provide or require a mechanism to limit the length of trial whatsoever, including as it relates to the information contained in the jury summons that the court sends to citizens pursuant to Jury Rule 4. Judge Gull's errant interpretation of Indiana jury rules created a situation in which Mr. Allen was required to seek a continuance of his speedy trial in order to assure for himself a trial where he could thoroughly present his defense without time restrictions. Judge Gull's bungling of Mr. Allen's speedy trial due to her misunderstanding of what the jury rules require in the summons only negatively affected the defendant and his constitutional rights, and not the prosecution, and thus provides a rational inference of bias against the defense and Mr. Allen. Yeah, I gotta say, that one, that negatively affected the defendant there. Because you were put in a catch-22 situation. It's either you go to a speedy trial where you don't have enough time to present your case or defend your case, or you get no speedy trial and we do it later. And that's exactly what happened. Additionally, at the May 7, 2024 hearing, Judge Gold cited several cases over which she has presided that lasted less time than the defense is requesting on this case, essentially chastising the defense for the amount of time it was seeking for trial. The length of a trial is determined by the number of witnesses, the amount of evidence, the length of the investigation, and the complexity of the issues involved. Yes, think of the Karen Reed trial now. How long have we been on that? How long has that been lingering on? That trial has been going on and on and on. How many trials have you seen last not just weeks, but months upon months? This case, I'm sorry, this is the case of State of Indiana versus Richard Allen, with its own set of facts, challenges, and potential pitfalls that could cause trial to last beyond what the parties expect. For example, several witnesses reside 125 plus miles away. If those witnesses fail to appear in spite of being properly subpoenaed, the trial may be delayed while the parties try to determine how to deal with a witness whose car may have broken down or who may have simply ignored a valid subpoena. These situations arise in trial, especially when in a factually complex trial with approximately 185 witnesses identified by the parties. Isn't that an interesting statement right there? Let's read that one again. These situations arise in trial, especially in a factually complex trial with approximately 185 witnesses identified by the parties. You guys ready for a show? You know, are you ready for a show? Are you ready for a journey? It is approaching. Additionally, of the approximately 185 witnesses identified by the parties, a dozen or more are expert witnesses whose testimony will generally take longer and will be more complex than fact witnesses. For this court to call the defense counsel irrational and unreasonable for stating the truth that they have never had a judge set a hard end date to a trial provides a rational inference of bias against the defense. Additionally, it is shocking and disconcerting that the court refused to place a limit on the time allotted to the prosecution, but absolutely limited the time for trial, thereby limiting Mr. Allen's time to present himself. Yes, clearly. Under the court's prior order, the trial was to last from May 13, 2024 through May 31st, 2024, thereby allowing approximately 13 days for the opening statement, testimony, evidence, rebuttal evidence, surrebuttal evidence, arguing of final instructions, and closing arguments of both parties. If the prosecution took 8 days to present their case, this would only leave 5 days for Mr. Allen to present his witnesses, which include at least 5 expert witnesses without even factoring in rebuttal evidence, surrebuttal evidence, and arguing of final instructions and closing arguments. Yeah, I think that 13 days for trial is absolutely mind-boggling how that could be expected. How could you expect that? The hard limit on the end of trial denies Mr. Allen his Sixth Amendment right to confront witnesses, his Sixth Amendment right to the compulsory process for witnesses, and his 14th Amendment due process right to present a defense. In the context of its request for Judge Gold to disqualify herself, this court's maligning of the defense counsel as irrational and reasonable, when in fact it was this court that was wrong in its understanding of jury rules and also wrong in its claim that the courts or courts statewide provide a hard end date to a trial, offers a rational inference of bias against the defense. Judge Gold's May 31st explanation for her denial of defense motions without a hearing provides a rational inference of bias. In its May 31st, 2024 order, when explaining why the court denied several defense motions without hearing, the court stated, quote, If pleadings on their face are not supported by the law or admissible evidence, judicial economy does not require a hearing. Close quotation. This court knows very little about this case, especially compared to the lawyers litigating the matter. Therefore, how could this court determine what evidence would be admissible or inadmissible until a hearing takes place and the defense moves to admit the evidence, subject to possible objection by the prosecution? Judge Gold's claim that defense evidence is inadmissible before conducting a hearing and before listening to the defense contextualization of the evidence surrounding their legal arguments provides a rational inference of bias against the defense. The court's denial of defense motions without a hearing, based upon the reasons that this court cites in its May 31st, 2024 order, establishes that this court is prejudging defense evidence as inadmissible. Also, this court claiming that the law does not support the defense pleadings before this court even hears any evidence is additional proof that this court is prejudging evidence. This court's denying the defense request contained in its pleadings without a hearing based upon her prejudging evidence provides a rational inference of bias. In the future, if this court denies defense motions based upon the court's belief that the defense pleading is, quote, not supported by the law or admissible evidence, close quotation, the defense then requests this court to identify the evidence cited in the defense pleading that this court believes is inadmissible, and then to explain why the court believes the evidence is inadmissible. Also, instead of simply stating denied without hearing, the defense will request the court to explain why the pleading is not supported by the law. Even concerning something as basic as a request for a recess, Judge Gull shows favoritism to the prosecution. On her May 31st, 2024 order, Judge Gull expressed that she does not show favoritism to the prosecution. However, Judge Gull has shown her differential treatment between the prosecution and defense in a variety of ways. Some are easily identified and some are less perceptible. For example, because cameras have not been allowed in the courtroom, it is difficult to hear Judge Gull's angry tone when addressing the defense versus how she speaks to the prosecution, and also to visualize the court's disdainful facial expressions she makes towards the defense versus the prosecution. In the future, the defense will likely request cameras in the courtroom for all hearings and trial for purposes of transparency and to better preserve the record. Ooh, that's rich. We'll read that again. For example, because cameras have not been allowed in the courtroom, it is difficult to hear Judge Gull's angry tone when addressing the defense versus how she speaks to the prosecution, and also to visualize the court's disdainful facial expressions she makes towards the defense versus the prosecution. Although it may seem petty or trivial to the court, the defense offers an example of her disparate treatment concerning something as mundane as how the court handles a simple request for recess during a hearing. Okay. I'm going to do that for you guys. You guys can go through that yourself and read it. So I'll just skip through that for brevity's sake. Okay. However, at the May 7th, 2024 hearing, the court treated the defense much differently when the defense sought a short recess to confer with their client on urgent matters concerning the positives and negatives of continuing for Mr. Allen's speedy trial due to Judge Gull's hard end date of May 31st, 2024. Following a back and forth exchange between Judge Gull and the defense counsel concerning the defense needing more time for trial, Judge Gull was allowing this occurred. I'll skip that too. Judge Gold did not playfully call Brad Rozzi ding dong, but instead questioned Rozzi's reasons for seeking a recess. Then Judge Gold surprisingly asked if the prosecutor if he had an objection to seeking a 5-minute recess so that the defense counsel could talk to their client about the important matters concerning seeking a continuance of a speedy trial. due to the trial court's unwillingness to provide more time to defense at trial. When a defense attorney requests a 5-minute recess to talk to their client on such weighty matters as their constitutional rights related to continuing a speedy trial, it should be met with a simple "of course" and should not require the approval of the prosecutor. Yeah, I have noticed that, by the way. Okay. Remember, it says, it sure seems like the defense is preparing to have to retrial and appeal with so much effort creating records. Can any of these filings be referred to? You know, I think that's exactly what we're looking at. The fact that Judge Gold treats the defense differently on such a basic matter as a request for a recess for a 5-minute recess provides a rational inference of bias, of course. This court failed to address the appearance of bias which exists in this case. Judge Gold claims in her order, quote, "As counsel should know, criminal cases are tried in a court of law, not in the court of public opinion," close quotation. However, the standard for recusal is not just to whether actual bias exists, but also to whether the appearance of bias exists. The mere appearance of bias and partiality may require recusal if an objective person, knowledgeable of all the circumstances, would have a rational basis for doubting the judge's partiality. The judge must consider both the actual bias and the appearance of bias when determining whether to disqualify herself. Judge Go appears to conflate the general concept that on occasion the public will vehemently criticize a judge with the defense's specific contention that many in the public are particularly criticizing her for what the public perceives is actual bias against the defense. As part of the legal reasoning contained in her order, Judge Go cites to be threatened with bodily harm and injury. She is not alone, as counsel have also received death threats and threats of bodily harm. Regardless, the defense sees no linkage between whether an appearance of bias exists and Judge Gold's mentioning that she or any other party has been threatened. Yeah, speaking of that, what about the prof? How many death threats are you going to send me? The emails which the defense attached to the motion and the memes the defense referenced in the motion detail how the public believes that Judge Go is biased against the defense. Of course, the public does. The defense agrees with this court that general complaints by the public concerning the court's rulings should not cause her to disqualify herself. It is true that many in the public have written both Judge Go and the Indiana Supreme Court to complain that the judge is wrong in various rulings, particularly whether the judge should allow cameras in the courtroom. However, these complaints would not support an appearance of bias. However, that is not what the defense is discussing in this motion. Although the defense believes actual bias exists, it is the appearance of bias against the defense about which the public has complained. It is the appearance of bias against the defense about which the public has written the Indiana Supreme Court. It is the appearance of bias against the defense about which the public has written Judge Gold. And it is the appearance of bias against the defense, the existence of which Judge Gold should recognize, and for which Judge Gold should voluntarily recuse herself. Failure to address other issues contained in the first motion to disqualify. This court addressed a few other defense issues contained in their second motion to have Judge Gold disqualify herself. The defense stands by those reasons as well and does not waive those issues for purposes of appeal. However, in its May 31st order, this court failed to address all issues contained in the defense's first motion to have Judge Gold disqualified, which the defense incorporated into its second motion. Right, so the defense does not waive those for purposes of appeal, and the judge did not address some of those issues in that first motion. The defense requests Judge Gold to review the first and second motion to disqualify and consider whether she feels obligated to disqualify herself from this case based upon the itemized reasons contained in those motions, as well as in this response. Who could argue that the appearance of bias against the defense actually exists? I would say if you asked most observers, they would agree, especially the informed observers, that the judge has exhibited or caused the appearance of bias against the defense to exist. And that enough is reason for recusal. Conclusion, the defense wishes to move forward and have this court conduct hearings, most immediately, to the request to have Richard Allen removed from the DOC to either Cass or Tippecanoe County jails while awaiting trial. This motion is intended to respond to Judge Gold's order for purposes of preserving the issues for the record and so that Judge Gold may consider whether or not she feels obligated on her own to recuse herself from this case, which remains an ongoing obligation whether or not the defense is seeking her recusal. Wherefore, the defense files its response to Judge Gold's May 31st, 2024 order for judgment of the court concerning her denial of the defense request for disqualification. Okay. And this is June 18, 2024. Okay, that's today. And many of you know that. Many of you are well aware that this was today. Okay. I don't know what more we can say. I really don't. I think that was a very good response. And notice of conflict. And I think she should go one or two ways. I think she should allow cameras in the courtroom or recuse herself. Hands down. No ifs, ands, or buts. Cameras in the courtroom or recuse yourself. So, God bless you all. I see that Joe Lewis is on and covering the same material. I'm sure many people over there are watching that. And please go enjoy Joe. And we will see you on show number 96. Let's Talk Delphi number 96. That'll be our next show. And yeah, I really don't. I think I basically I don't have a lot to say about that. That just summed my feelings up just perfectly. Recuse yourself or allow cameras in the courtroom. I don't see any other way. So with that, thanks everyone for being here. Lisa, Kayla, Lambert Co., ACV, Bonnie, thank you so much for the super chat again. Frenchie6290, Bill was here, Pam Sheehan, Noe Amos, Rebecca Ann, who else was here? Captain Underpants, Tracy Fleetwood, Icy Cat, Michelle was here, and anyone else. And everyone watching, please hit the like on the way out. Do that for me. Please hit the like. Appreciate your likes. Who knows when it will be that we get another filing. But wow, this one is good. This one was interesting. And I got to say, as time has gone by, each filing I feel has become more and more sober minded. And this one was very sobering and very sober minded. I mean, how can you argue with most of that? I mean, I would say 90% of that can't really argue with in my book. Um, Anyhow, we'll be talking to you soon. So, good night, everyone. No need to sugarcoat it. She has blatantly rude with bias on many filings, not providing any law to back it. She determines who can be a witness, who cannot. That does not show bias. Does that not show bias? She's being she's being unapologetic in her appearance of bias. So, with that said, what else do you expect? That's why I believe she should just allow the cameras and then function normally. Okay, and if you don't want to allow the cameras, then go ahead, step down, and recuse yourself, and then we'll see what else happens. But God bless you all. I'm out of here. ACB says I'm headed to church this evening, but we'll watch replay. Peace and God's blessings to you all. Well, thank you, ACB, and God bless you all. And Christ is King, and we love you all, and we love ourselves too. And hey, I am whoever you say I am. If I wasn't, why would I say I am?